Can you hear me?
Yes. What's your name, sir?
Yes, I'm here to make a special appearance.
What's your name, sir? Can you tell me your name?
Don Lyons.
Okay, we're on 2508, CM 2346, State v. Don Lyons, who is here today via Zoom. State's again present. Let's see, advised at your initial hearing, you wanted to proceed pro se, without an attorney. Is that still your intent today, sir?
Say it again.
Is it still your intent to go forward without an attorney?
Yes, sir.
Okay, so we have two options today. You can either ask for some more time to either put together a defense or hire counsel or talk to the state about any potential resolution, or we can simply set this matter for a bench trial. Which of those two options would you like today, sir?
I would need to request a continuance to work on my defense.
Any objection? I say
No objection.
okay. Looking to age of the case, that's fine. So I'm going to reset this for December 22nd at 8:30. So Mr. Lyons, we'll see you back here on that date and time.
Say it again. You said
December 22nd at 8:30.
December 22nd. All right, thank you.
Yep. All right, so we're on 2508 CM 2346, State v. Don Lyons, who's here today in person. State is also present. So we're here. All right, so the state has filed one additional charge, and it's for count 3 operating vehicle with an ACE of 0.15 or more. And the state alleges that on about July 21st of this year in Montgomery County, state of Indiana, you did operate a vehicle with an alcohol concentration equivalent to at least 1,500ths of a gram of alcohol per 100 milliliters of your blood. Class A misdemeanor carries with it a penalty from 0 to 365 days, Montgomery County Jail, and a fine of up to $5,000. Do you understand the allegations against you and the possible penalties?
I'm here to make a special appearance, and I had sent a motion.
Yeah, so that was filed this morning.
A motion to get this dismissed.
Okay, since that was just filed today, I don't even know if the state's received a copy of that. I'm not going to set that for hearing today, but what we'll do is we'll set this for another pretrial conference, and that we can address that motion at that point. We'll do that. Set that, say January 26th at 9:30.
What date is that?
January 26th.
What that date? Well, no, I'm mistaken.
Okay, you want to do the 28th?
Yeah, 28.
Okay, we'll say January 28th at 10 a.m.
Yes, sir.
All right, so we'll see you back here on the date and time, sir.
All right, thank you.
Thank you.
Hey everyone, welcome back. In today's video, we take a closer look at an individual I've been following over the past few months, who is now appearing in court over a DUI case and has chosen to represent himself during a bench trial. As you might expect, the situation quickly becomes complicated and doesn't unfold the way he likely anticipated. We'll begin by reviewing his first 2 court appearances, then move on to the 3rd hearing, and finally highlight the most important moments from the trial. Let's take a closer look at how everything develops. Next voice, next voice. At this stage, we see a familiar pattern as he focuses on questioning the court's authority, referring to special appearances, and presenting arguments that do not carry much relevance in a standard legal setting. These points are raised early on, but do little to influence how the proceedings move forward. With that portion addressed, the case continues into his 3rd court appearance, where the situation begins to develop further and the overall direction of the trial becomes clearer.
All right, Mr. Lyons, can you hear me?
Yes, I hear you now.
Okay, we can get your face on camera there.
That's what I'm trying to do.
There we go. This is 2508 CM 2346, State v. Don Lyons, who's here today via Zoom. State's here in the courtroom. We're set for a pretrial conference Lyons, the first question is, you've been appearing pro se. Is that still your intent, or do you intend on hiring counsel, or do you want me to consider appointing an attorney for you?
No.
Okay. So I'm going to advise you, just in proceeding pro se, you are going to be held to the same standard as if you were an attorney. You're going to be expected to understand the rules of trial procedure, rules of evidence, rules of criminal procedure. Do you understand all that if you go forward without an attorney?
Yes.
Okay, so I think
I had wrote an affidavit, and I'm still waiting for a response.
okay, and I see that affidavit, and I think we received that the date of our last hearing. It doesn't look
Correct.
to doesn't make any specific requests. It's a request for dismissal of charges, and this does not comply with Criminal Rule 2.7. It's also not an appropriate motion to suppress.
I have to object to that.
Understood. So what I'm going to do is I'm just going to set this matter for a bench trial. Set that April 1st at 1:30. So that's going to be the court's order for today. This will be set for a bench trial April 1st at 1:30. And all parties are going to be ordered to be here in person on that date.
April 1st, what time?
1:30 p.m., sir.
All right, thank you.
Okay, and that's all for today.
Nothing significant takes place during that appearance, aside from a clear indication that he is still unfamiliar with how the process works. As the case moves forward, that gap in understanding continues to show. When the bench trial begins, he makes very little effort to question or respond to the testimony presented by the witnesses, which becomes an important factor in how the proceedings unfold. For the sake of time, we'll move directly into the trial and skip most of the arresting officer's initial questioning, since it mainly covers routine procedure. Instead, the focus will be on the cross-examinations, which provide a clear look at the challenges of handling a case without proper preparation.
For the record, I'm here making a special appearance.
Hold on, I'm going to call the case. It says 2508 CM 2346, State v. Don Lyons. It's here today in person. State's President and Deputy Prosecutor Tyler Trulock. Set today for a bench trial on counts 2 and 3. Count 1 was previously dismissed. Michelle, I just say you wanted to note something before we begin?
Yes, I'm here for make a special appearance.
Okay, and what do you mean by that?
Like I know I'm here to represent myself and challenge the jurisdiction.
What's your request to challenge the jurisdiction?
The OWI
Okay.
that was there, that they had a warrant for to take my body to it, but I don't recall.
The proceedings begin as the court calls the case of State versus Don Lyons, noting that it is scheduled for a bench trial on counts 2 and 3, while count 1 has already been dismissed. Deputy Prosecutor Tyler Trulock is present as the judge addresses the defendant and asks him to clarify an earlier statement. The defendant explains that he is representing himself and refers to his appearance as a special appearance, stating that he intends to challenge the court's jurisdiction. When the judge requests further detail, he points to the OWI charge and argues that officers claim to have a warrant to take him into custody. However, he states that he has never been shown such a warrant and uses this as the basis for questioning the court's authority in the case.
Okay, well, the time for challenging any of the procedural issues or evidentiary issues has come and gone. Today we're set for a trial on the facts that matter. So if you have issues with the evidence being introduced as it's being introduced, you can make appropriate objections. We're going to go forward today. State, you ready to proceed?
Yes, sir.
Go ahead.
Your Honor, the state calls Trooper Devin Walsh.
Any questions, Mr. Lyons?
Yes. What side of the car you was on when you first said you had smelled? When you had first asked, was y'all smoking any marijuana in the car?
Passenger side.
And then right after that, you had said you had smelled alcohol, right?
Yes.
It was on the passenger side?
Smelled alcohol on the passenger side and on the driver side.
But you was on the passenger side first, right, when you said it, correct?
Yeah.
Alright. So when you came to the driver's side, and I got out the car and I told you I refuse to take the test. We went to the hospital. How can I say? When did you present me the warrant?
I read you the warrant right before we drew your blood. Like I'm supposed to.
This is on file.
It's on camera.
Is it on file though?
They have my body camera. They have it all.
On file.
So you have to ask questions about it.
So you don't know if it's on file or not.
They have all my body camera, dash camera, and
You don't know.
all that. I sent it to them, so I would assume so.
When you said the warrant was signed around 6:21.
Well, it was around 6:21, so I'd have read you the warrant that I did. So I did read it to you right before the blood draw happened.
You have any proof of the audio?
Audio, it's on my body camera. It's on all the time.
I can't see it. And I see it. But I really don't recall. And if there was a warrant, you know what I'm saying?
It was
go
attached.
about it like that. But I don't recall no more.
Well, I'm sure to say that.
So
You have any questions?
Like I was on, I do, but not right, not at the moment.
Anything up that state?
No, you're.
You can step down, sir.
Thank you, sir.
The suggestion being made is that the defendant may not recall details about the warrant due to his level of intoxication at the time of the incident, which could have affected his memory of what occurred.
Ms. Dominguez, is there anything else you'd like the court to know at this point?
No.
Thank you, ma'am.
Mr. Lyons, do you have any questions for this witness?
Yes. I know it was a while ago, but you know around the time that they took my blood?
I don't remember.
That's all I had.
Anything up that state?
No, you're.
You can step down, ma'am.
Okay.
Mr. Nurtown, is there anything else you'd like the court to know at this point?
Do not believe so.
No. Thank you.
Do you have any questions, Mr. Lyons?
No, sir.
You can step down, ma'am.
This is the only witness the defendant makes any real effort to question. But even then, his focus remains narrowly fixed on whether a warrant was actually read to him while he was intoxicated and receiving treatment at the hospital. Instead of exploring broader legal issues or raising procedural concerns, he does not engage with questions that would typically be used to challenge probable cause or the validity of the process itself. As the trial continues, the next two witnesses include the hospital nurse and the lab technician responsible for analyzing his blood samples. These sections of the hearing move quickly, with attention centered mainly on his cross-examinations, which ultimately provide no meaningful or substantive challenge to the evidence presented.
Mr. Lyons, do you have any evidence to present?
And y'all didn't give me the motion of discovery. I was thinking y'all was gonna send it to me. I didn't know I had to file for it. That's my ignorance. I don't have no evidence. No, sir.
So today's trial, the state needed to prove, carry their burden, need to prove beyond a reasonable doubt on count 2 that Mr. Lyons had operated a vehicle while intoxicated, and on count 3 that it operated with an ACE of 0.15 or above. State has proven that he was operating a vehicle, and through the expert testimony has proven both counts 2 and 3 beyond a reasonable doubt. We can proceed to sentencing. Mr. Lyons, is there anything you'd like me to consider on sentencing?
I mean, my grand got to get back home today, and I really don't remember or recall them showing me that warrant in that hospital. I kind of remember that night for the most part, but I was hoping to see the audio or see the documents of timing of the warrant. But what they were presenting, I just thought it'd be nice.
Any sensing state?
Just a few questions here. Mr. Lyons, are you currently employed?
Yes, sir.
Where do you work?
Work at the Penn Station right now, Earthsport.
Okay. Is that a full-time job?
Yes, sir. Now it is. I was working 2 at first.
Okay. And where do you live?
Well,
Okay. Louisville, Kentucky.
yes, sir.
Okay. Mr. Lyons, do you have any criminal history of any kind?
Yeah, a little bit. Like the criminal history,
Yes.
I got a little bit. Mainly tried. Yeah, but
So what have you been convicted of criminally?
that's some marijuana. Some marijuana. Pretty much.
Is it possession of marijuana?
Yeah, that's
Okay. Is that the only thing you've been convicted of?
I think of right now.
Okay. No previous operating while intoxicated convictions, anything like
No,
that?
it's my first time. The first time.
Thank you, sir.
As the judge ultimately explains, the verdict is based on the evidence presented in court along with the expert testimony, which went unchallenged during the trial. With no effective rebuttal from the defense, the court accepts the prosecution's case as proven. As a result, the defendant is found guilty. Now that the decision has been delivered, the next step is to move on to sentencing, where the court will determine what consequences will follow. Let's see what kind of sentence is handed down and how the judge addresses the outcome of the case.
Is any other evidence to the state?
No.
What's the state's request on sentence today?
Your Honor, state doesn't have any reason to doubt what Mr. Lyons said about this being his first operating while intoxicated conviction. The state is concerned by the fact that Mr. Lyons was operating a vehicle with an alcohol concentration above 0.15. However, it does not appear that Mr. Lyons has many, if any, ties to this community. So the state's first inclination as to sentencing would be to ask for just a short executed sentence for him to be done with this case. If the court's not inclined to do that, the state would just request a 365-day sentence suspended to probation, as well as a reasonable fine and license suspension. Thank you, Your Honor.
So, yeah, those are my things to consider. Understand if I would put you on probation, it'd be a misdemeanor probation that is difficult to transfer across state lines, and that's going to be very difficult to have done with you living in Louisville, Kentucky. So what the court's going to do today, given your lack of criminal history, is I'm going to sentence you to 10 days in the Montgomery County Jail. That's 5 actual. So you've got credit for 1 actual day already when you were first arrested. So you're going to have 4 days remaining to do. So you're going to be taken into custody, placed in the custody of Montgomery County Jail today. You're going to be released 4 days from today. And there's going to be court costs of $189.50. And I'm not going to impose any additional fine. There's a $200 alcohol countermeasure fee. There's also going to be a 90-day license suspension that's going to go into effect tonight at midnight.
That's suspensions for the state of Indiana?
Yes.
All right.
So I'm not sure how that transfers to Kentucky. That's going to be the order for today. So you're going to be remanded in custody.
All right. So what about I don't know, my granny though. She can't really see like that. Like I gotta help her get her, you know?
Well, sir, you've known for quite some time that you were scheduled for trial today.
Yeah.
And so plans you've made
Right.
are on you. So that's going to be the order for today. And I will notify you have 30 days to file a notice of appeal if you want to appeal this decision.
It looks like his grandmother may need to arrange another way to get home, which adds a personal consequence to the outcome of the case. The situation also serves as a reminder of how important it is to be dependable when others are relying on you, including making responsible choices and understanding how the legal system actually works instead of taking unsupported sovereign citizen arguments into court. That brings this video to a close. It's been a little while since the last update, and although this case was relatively brief, there are many more similar cases to cover in upcoming videos. If you enjoyed the content, feel free to leave a like, and if not, a dislike is also welcome. Either way, you can drop a comment below and subscribe with notifications turned on so you don't miss what's coming next.